Welcome to another edition of Energy Independence Magazine. I'm your host, Sean Reynolds, and today we will continue our discussion on the important issue of contractor fraud with another outstanding professional expert, Ms. Donde McCament, Deputy District Attorney for Southern California's Orange County. Currently, Ms. McCament represents the DA's Public Works Unit, dealing with prevailing wage violations and the unlawful disregard for laws governing public works, which we have learned is only the tip of the iceberg regarding contractor fraud and the practices of unethical and illegal contractors. Welcome to the show, Ms. McCament.
Thank you.
It's good to have you here. The Orange County District Attorney's Office of Public Works Unit responds to violations of contractors abusing prevailing wage statutes and other laws governing public works.
Yes, it
So
does.
would you take a few minutes and explain to us what prevailing wage is?
Certainly. Prevailing wage is a wage that's set by the legislature, or actually the Department of Industrial Relations. It's what you would say a minimum wage is for that classification of work, depending on what county the work is actually going on. It only pertains to public works projects, so it's money that are public funds. So it's based, or it's written to ensure that public money is well spent and attracts really the best workers possible.
And now the unit, of course, that's not the only thing they enforce. There's many other things that they enforce. So could you go over some of the things that they enforce on contractors?
Absolutely. In all of the cases that we've investigated, even in the Public Works Unit, there's been insurance fraud, there's been tax evasion, there's been EDD fraud, we have some just out and out bribery for contracts or a better position in getting the public works projects. We've seen the schemes kind of run the gambit. So although we've always seen a component of the contractor cheating the worker and not paying them prevailing wage and pocketing that money, that it doesn't seem to be exclusive.
As far as prevailing wage abuse is carried out, we've heard from others on previous shows that employers can do things like simply underpay their employers, but can get much more dishonest, even demanding kickbacks. Like they'll take them to the bank and they'll ask them to give some of the money back. Is this in your experience? Have you heard things like this in your experience?
Oh, absolutely. The schemes get they're quite sophisticated, actually. It's funny that you mentioned the kickback scheme because we had a case where the employer, the contractor, would pay the workers their prevailing wage, so all of the paperwork looked correct. But in order to have a job the next day, the worker had to go to the employer's bank, cash the check, and then return half the money back into his account, and then bring a deposit slip as proof so that they would still have a job the next day. There's also another scheme that is prevalent in the industry is they'll have all of their workers sign a loan document saying that they've loaned the money. So anytime there's a kickback or Department of Industrial Relations or somebody investigates, the contractor will produce the loan document saying, well, he was just repaying a loan. But it gets very obvious. In one case that we had, the contractor had every one of his 22 employees sign the same loan document for the same amount of money, and then tried to say that he gave all of them $10,000 in cash out of the goodness of his heart.
Wow.
So
every employee
exactly.
on that job had a loan.
Exactly.
Oh my gosh. Now, how does your office start to build the case?
Well, we'll usually get a tip either from an employee, a contractor, somebody, sometimes it's an awarding agency, unions, compliance agencies. And once we get the initial information, the first thing we look to is whether we have jurisdiction in Orange County, whether there's some tie to Orange County so that we could prosecute the case. Then we start ordering documents, articles of incorporation, insurance documents, certified payrolls, bid information, inspector logs for the project. And that's where it really starts. And that takes a good few months to get those documents and really start looking at the company to see whether or what type of fraud they're engaged in.
Does the Orange County Public Works Unit have their own investigators?
Yes, in fact, we do our investigation really from the ground up. So we build the cases from the ground up. We are staffed with 2 full-time investigators now, an investigative assistant and a paralegal.
On a previous show, we had the gentleman from the Center for Contract Compliance. And they were saying that mainly the district attorney's office is reactive other than active in it. But now this, with investigators, now you are going into and doing your own investigations.
Yes, and I think that we've always been reactive because we're a law enforcement agency, so we investigate the crime after it's happened. The Center for Contract Compliance has been a wonderful source of information, but when you're talking about putting together a criminal case and going into court and filing it, we really need to do that investigation with sworn law enforcement agents.
And what scope are we talking about? How big is the problem here? At least in Orange County, how big is the problem? Is it growing? Is it being managed?
Well, that's an interesting question because I don't know at this point that there has been management. I think that, well, I know that we're the first district attorney's office to form a public works unit to specifically combat the fraud that seems to be very prevalent in the public works arena.
On both sides of it, let's take the first part. What are some of the things that the awarding body can do to pre-qualify these contractors? What are some of the things that they can look out for, and what are the tools at their disposal when they're going into qualifying these bids?
Sure. Well, you can always look on Contractor State License Board. They have a wealth of information of the actual license. It's as simple in some ways of checking with the insurance company. We've had cases where the contractor has given the awarding agency a piece of paper showing that they have workman's compensation insurance, and it's been forged. And the awarding body just never called. So actually asking the insurance company to send them the document, or calling and following up, actually looking on Contractor State License Board for somebody's contractor's history, going to the Department of Industrial Relations website. They've recently started a program where any contractor that works in public works must be certified by the Department of Industrial Relations. So they'll know if anybody has any prior bad behavior from the Department of Industrial Relations, any prior felony convictions, things like that. So there are a lot of useful agencies out there. Unfortunately, it just takes time to call them up and find out what they know.
And the second part of my question is there culpability for any of the officials or the awarding agency if they hire a contractor that is not supplying the legal requirements that they should be doing?
As in any field, we've found that there are people that follow it to the letter, that pay quite a lot of attention to the project and monitor it. And then there are others that don't really monitor as closely as they could.
Aren't doing as much of their due diligence.
Right. There's one example that there was somebody who was a project manager that was in front of a grand jury when we were presenting a case in front of them, and had no idea what she was really saying and how the grand jurors reacted afterwards. But when asked, why didn't you watch this project more closely? Why didn't you find out what was going on? The project manager told the grand jury, well, it was only a $200,000 project. It wasn't a large project, so I just didn't bother. And the grand jurors were very offended by that attitude. And unfortunately, we found that attitude more than we'd like to, in that, well, it's the public's money, and, well, you know, it's not my money, so I'm not paying attention.
Actually, part of the problem, because there's so much money out there to be awarded with some of these projects. one person that gets hurt in all of this, of course, is the worker. It's the person that has to have a job. He's coming out there, he has skills. What are some of the things that a worker can do if they feel that this person I'm working for isn't being on the up and up?
Right. Well, the worker can always go to the awarding agency. If they're not getting any kind of response from them, they can always go to a local compliance agency like CCC. They respond to a lot of workers' complaints all the time. And if they belong to the union, they can speak to their union about that. They always have the recourse, and we've had open investigations and spoken to workers that have called us directly as well.
What can you do once you are focused on a case? What are some of the things that you can do?
Well, I can tell you that in an investigation, what we do is we order the documents we'd already spoken about up front. We compare all those documents. We can subpoena documents. Once we compare everything and we speak to workers, even if they're necessarily reluctant to come in or they're covering for the contractor, once we file the case, we can still bring them in under subpoena to testify. And we've had that happen before. And luckily, once that worker was in front of jurors and was sworn to testify, decided not to protect the contractor any longer. Once we compare all of the information, though, before filing, we will generally execute a search warrant, both for bank statements as well as the contractor's documents at his office, so we can compare everything.
And now, what can happen to these contractors? I mean, what's the least, and what's the worst?
Well, the least, of course, is just defined by the Department of Industrial Relations. And that's what they've done before. That's why we really try to focus on contractors that have been through the process with the Department of Industrial Relations. They've paid their fines, they've paid their penalties, they've had to pay assessments, and their behavior hasn't changed at all. So once we focus on them, it can be anywhere from a probationary sentence to a prison term. We've had 3 cases resolve thus far. 2 of them were owners of contracting companies, and they received 2 years state prison, along with all the restitution for the back wages for the workers, as well as insurance company restitution and back taxes. And then there were 2 defendants that were managers of another company that was a Northern California company operating a satellite office down here, and they both received 6 months.
But in the public works arena, it is, for the awarding agency, it is always best to do their due diligence and to find a contractor that is reputable.
Absolutely, and it's, I've heard before, well, aren't we saving money taking the lowest bid? So aren't we doing the best we can with our public funds? In the experience that my investigators and myself have had, a lot of those cases, they end up spending more money than the original bid or what the assessment was, simply because the work is substandard. It has to be redone. There's a lot of change orders that go in because nobody can do the job for the amount of money that was actually bid. In one case, there was a wall that was built in an elementary school, and they used unskilled laborers, and the contractor pocketed the money. Well, the wall wasn't built to specifications and was falling over. So the school ended up paying more money to demolish the wall than they had intended to originally pay.
What are some of the things that a conscientious worker should do? Because many of these workers move from contractor to contractor. When a job is over, they're finding another job. Well, what can they do to protect themselves? What sort of records can they keep?
Certainly. Well, document. And that means even from, we've seen workers keep a calendar, just have a copy of a calendar and just write down how many hours they worked that day and where they worked that day. That becomes very credible. We've had people keep notebooks about what they actually worked on, who they worked with, everything detailed down to that day. We had a case where I was talking about, where the worker had to actually return the deposit slip to the contractor to prove that he had put the money in there, so he wouldn't have the deposit slip any longer. So the workers started getting smart, and they started taking pictures of everything with their cell phones.
Okay.
Right? There are some contractors that will not claim they have as many workers on the project that they do. So we have cases where the workers all line up on the work truck or next to the work truck with a date stamp on it, and they take a nice big picture of all 20 of them standing there, and the contractor reports 2 workers. Things like that. Any way to document how many people were on the scene, what kind of work they were doing, the hours that they've kept, keep copies of paychecks, pay stubs, anything like that.
Now, when you're doing your investigations, do you find that organized unions are doing these type of egregious errors, or are they somebody that you can stick with?
I don't believe that we've seen a violation by a union itself. We have seen union workers that were aware of prevailing wage and took the job just so that they would be getting a paycheck. And that's almost an example of how rampant it is in public works, that even union employees are taking those jobs just so that they do have a job to work.
But by and large, when the awarding entity is hiring a contractor, a union contractor, then they're not going to run into these problems.
We have not usually seen that, no.
And where are you getting most of your information these days? Is it coming from your own investigators? Is it coming from places like the CCC, the Center for Contract Compliance? Is it coming from the workers? Where's the most information coming from right now?
I would say the majority of the information are coming from compliance agencies like CCC that give us a tip and give us that initial information, that and the Department of Industrial Relations, because we can work a case alongside of them. They can go after the penalties, the fines, and the assessments, and if somebody has gone through the process enough times with them and the conduct is egregious enough, we'll complete a criminal investigation the same time that DIR is investigating their case.
And how long will that investigation take? Like what's the scope? Are we talking months, years?
Sure. I can say very proudly that we worked on a case with Department of Industrial Relations, and from the time we began the investigation to the time that we went to or convened a grand jury, that was 4 months.
Thank you, Ms. McCament. There are many factors to consider when choosing a contractor. The lowest bid may be the best solution, but only if that contractor is law-abiding and ethical, providing a trained, qualified, and fairly compensated workforce. The Inland Empire Labor Management Cooperation Committee, representing the International Brotherhood of Electrical Workers and the National Electrical Contractors Association, believes that a fairly compensated, highly trained professional organization supplies not only the best solution for your project needs, but supports the local community with a fair and sustainable workforce in order to build the future. We appreciate Donde McCament for joining us today and applaud the efforts of the Orange County District Attorney's Office. For Energy Independence Magazine, I'm Sean Reynolds. Thank you.